State of Utah versus Kouri Richins. Counsel for the state and the defendant are present. Ms. Richins is present as well. The court is informed that the jury has reached a verdict. I do not know what it is. We'll invite the jury in a moment. When I do, I'll ask the foreperson a simple yes or no question. Have you reached a unanimous verdict? I expect that person will say yes. I'll ask them to hand the verdict to the bailiff, hand it to me. I will read the verdict. This brings me to important instruction number 1. There can be no outward reactions whatsoever to the verdict. These folks are here against their will. They, all the lawyers, Ms. Richins, every attendee, my court staff, the bailiffs, everybody deserves your respect. There simply cannot be any outward reactions. You have to keep your hands folded in your lap. If you feel overcome with emotion, just look down. We cannot have any outward reaction. Second, once the verdict is read and the jury is discharged, you need to stay seated and follow the deputy's instructions about how we will leave the courtroom in an orderly fashion. If anybody in here can't follow these instructions, this is your chance to leave. All right. Fair warning. Counsel, Ms. Richins, it is my practice to ask all the lawyers and the defendant to stand in respect for the jury as I read the verdict. I just don't want you to be surprised. Okay. Mr. Bloodworth, are we ready for the jury?
Yes, Your Honor.
Ms. Lewis?
We are.
All right. Messaging. Oh. Okay. Folks, please have a seat as you come in. Please have a seat. Ladies and gentlemen, would the foreperson you've selected please stand? May I ask you a yes or no question? Has the jury reached a unanimous verdict? Would you please hand the verdict form to the deputy, and you can have a seat. Thank you. I'll take All right. Counsel, Ms. Richins, please stand. Count 1, aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of aggravated murder. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count 1 beyond a reasonable doubt. The homicide was committed for pecuniary gain, and the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Count 2, attempted aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of attempted aggravated murder. We, the jury, unanimously agree the prosecution has proved the following circumstance or circumstances regarding count 2 beyond a reasonable doubt. The attempted homicide was committed for pecuniary gain. Count 3, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 4, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 5, forgery. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of forgery. It's signed by the foreperson. Please have a seat. Madam Foreperson, is this the verdict that the jury reached unanimously?
Yes, it is.
Okay, you may have a seat. Ms. Lewis, Ms. Nestor, do you wish the jury to be polled?
Yes, please.
All right. Folks, I'll ask you the same yes or no question, one at a time, starting on my left, working this way. Front row first. If you could show me your lanyard number as I ask you. Juror number 5, is this the verdict you voted in favor of?
Yes.
Juror number 4, is this the verdict you voted in favor of? Juror number 3.
Yes.
I can't see your number, I'm so sorry. The foreperson, I just need to ask you again, I'm sorry. Juror number 2.
Yes, it is.
Juror number 1.
Yes, Your Honor.
Sir. Juror number 8.
Yes.
Juror number 7.
Yes.
Juror number 6.
Yes.
All right. Counsel, is there anything further on this case before the jury is discharged? Mr. Bloodworth.
No, Your Honor. Thank you.
Ms. Lewis.
No, Your Honor.
All right. Ladies and gentlemen of the jury, this trial is now finished. Thank you for your service. The American system of justice relies on your time and your sound judgment, and you have been generous with both. You serve justice by your fair and impartial decision. All of my previous admonitions are now lifted. You may speak about this case with anyone or with no one at all. It is entirely up to you. You might be contacted in the future by the press or by the lawyers. You do not have to talk with them or with anyone else, but you may if you would like. The choice is yours entirely. I'm now turning to the attorneys and instructing them to honor your wishes as officers of the court if you indicate that you do not want to talk about this case. If you do talk about the case, please respect the privacy of your fellow jurors. The confidences they may have shared with you during deliberation are not yours to share with others. Thank you, all of you, for your service. Please rise for the jury. All right, please have a seat. Ms. Lewis, we need to get a pre-sentence investigation report, and we need to set sentencing. I imagine, Mr. Bloodworth, that the state would request that that be special set.
Yes, Your Honor.
Okay. Ms. Lewis, does defendant waive the 45-day limit for sentencing?
Yes, we will.
All right. call up my calendar. Should we be looking in May, Ms. Lewis?
That's fine.
Do you have a sense of it, Mr. Bloodworth? April is not possible. In May, do you have a sense of when would be appropriate?
Your Honor, can I step back and talk to the victim's family?
Sure. And Ms. Lewis, if you need a moment to confer with anyone.
Your Honor, any day in May works.
Without having to move something, which I am, of course, willing to do, I could do it during the week of May 25 or the morning of May 13. But if those times don't work, or if the week of May 25 is too far out, I'll move something to accommodate council schedules. Ms. Lewis, why don't I begin with you?
Either of those days would work for the defense.
Is a morning enough time?
Yes, sir.
Ms. Lewis?
Yes.
Okay. We'll set sentencing for 9:30 a.m. Wednesday, May 13. We're hereby referring Ms. Richins for the preparation of a pre-sentence investigation report. Ms. Lewis, anything else on the record today?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
Ms. Richins, I'll see you again, May 13, 9:30 a.m. I need everyone to stay seated, follow the instructions of the Summit County deputies. The court is in recess. Travel safely.
Good morning. Madam Clerk, we have a verdict. Yes, yes.
We're waiting on a family member, Your Honor, if that's okay.
Sure, yeah, yeah. Okay. Yes. Okay. Do we have everybody?
I believe so, Your Honor.
Okay. Let's bring in the jury. Oh, the alternates. We need to get the alternates. Okay, they're en route. Let's give them a minute. I think they were bringing the alternates around? You got everybody? Okay,
And Your Honor, you could just let the jury know that they wanted to stick around as long.
sure. You can bring them in. Yes. All right. Good morning. I understand that you have a verdict.
That is correct, Your Honor.
All right. If you could hand it to the I'll take a look. All right. And would the attorneys like to review it at the bench?
Yes, Your Honor.
Okay, I'll just let you all, the attorneys, come up for form. All right, I'm going to have Madam Clerk Johnson publish the verdict.
In the Superior Court of Gordon County, State of Georgia, the State versus Susan Ember, case number 15R456, as to count 1, malice murder, guilty. As to count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 5, possession of a firearm during the commission of a crime, guilty. Dated the 16th day of January 2026, signed by foreperson Reginald Bernard Hall.
All right, thank you. All right. Anything from the state or the defense?
Nothing from the state, Your Honor.
No, Your Honor.
Is there a request of any polling of the jury?
Just a moment, Judge.
Thank you. Please be seated. Ladies and gentlemen of the jury, welcome back. Who is the foreperson? Thank you. Has the jury reached a verdict? Yes. And is it a unanimous verdict? Yes. Thank you. Will you please hand it to the bailiff? The clerk will now read the verdict form.
State of Utah versus Megan Sunwall, count 1, aggravated murder. We, the jury, unanimously find the defendant, Megan Sunwall, is guilty of manslaughter. Count 2, obstruction of justice. We, the jury, unanimously find the defendant, Megan Sunwall, is guilty of obstruction of justice. We, the jury, unanimously agree the prosecution has proved the following act or acts beyond a reasonable doubt. Defendant altered, destroyed, concealed, or removed any item or thing, namely deleted text messages between the defendant and Casey Terry. We, the jurors impaneled in the above case, find the defendant, Megan Sunwall, guilty beyond a reasonable doubt of obstruction of justice as charged in count 2 of the information. unanimously find beyond a reasonable doubt the defendant obstructed the investigation of the following criminal offense, manslaughter. Dated the 24th of March 2026, signed the jury foreperson.
Does either counsel wish to poll the jury?
Not from the state.
No, Your Honor. Thank you.
Ladies and gentlemen of the jury, your service is now done. As I've stated before, we appreciate your attention and efforts in this matter. We know the time that this has taken out of your lives, and we appreciate your service. You are now, counsel, any objection to discharging this jury?
None, Your Honor.
Not from the state.
All right, you're now going to be excused. You are free to talk about this case with anybody you want. You're also free to not talk about this case if anybody has questions for you. But you are no longer under the admonition. Thank you for being here. Please be seated. Counsel, based upon the verdict, I'm going to refer this to the Utah County Office of Adult Probation and Parole for preparation of a pre-sentence report. We need to get a sentencing date to come back.
I might guess that we need a special setting.
Where are we looking, Brooke? That would work. What about the morning of May 4th? 8:30.
That would work for the state.
Sorry, Your Honor. Having calendar troubles. That looks like it would work for defense, Your Honor.
May 4th at 8:30. We will come back for sentencing. Ms. Sunwall, someone from Adult Probation and Parole will be meeting with you to prepare a pre-sentence report and recommendation. Counsel, anything else we need to cover before we adjourn?
Not from the state.
No, Your Honor.
All right, counsel, I want to thank you once again, all of you, for the professionalism that you've exhibited throughout this process. It's a tough process, and it's not easy, and it's about as serious as it gets. And I just want to thank you all for your help in this. All right, we'll be adjourned. Thank you all.
All right. We're now back in session. You may be seated.
Your Honor, we are back on the record in the Judy Church matter, and the jury has a verdict.
So we've been informed the jury has a verdict. They're lining up. They're coming into the courtroom in just a moment. I just want to make sure that everyone in attendance understands that there's to be no reaction to the verdict, whatever it may be. I expect everybody to remain composed and stoic, and I expect everyone's best effort in that regard. With that, we can bring the jury in.
All right, for the judge. Judge and the defendant remain standing. All others be seated.
Mr. Foreperson, has your jury agreed upon a verdict?
Yes.
May the court have the papers, please?
Thank you. The verdict is in order, and you may inquire.
Mr. Foreperson, what say you to indictment 2377 CR 14001, charging the defendant Judy Church with murder in the first degree? Is the defendant guilty or not guilty? And if guilty, guilty of what and on what theory?
Guilty, offense as charged, deliberate and premeditation, and extreme atrocity and cruelty.
Mr. Foreperson and ladies and gentlemen of the jury, hearken to your verdict as the court has recorded it. You, upon your oath, do say that the defendant, Judy Church, is guilty of murder in the first degree on the theories of deliberate premeditation and extreme atrocity and cruelty on indictment 2377 CR 14001. So say you, Mr. Foreperson?
Yes.
So say you, all members of the jury?
Yes.
Would you like the jury to be polled, counsel?
Yes.
So say you, juror in seat number 1.
Yes.
So say you, oh, I'm sorry, juror in seat number, it's okay, sorry, juror in seat number 1. So say you,
Yes.
juror in seat number 2.
Yes.
So say you, juror in seat number 3.
Yes.
So say you, juror in seat number 5.
Yes.
So say you, juror in seat number 7.
Yes.
So say you, juror in seat number 8.
Yes.
So say you, juror in seat number 9.
Yes.
So say you, juror in seat number 10.
Yes.
So say you, juror in seat number 11.
Yes.
So say you, juror in seat number 12.
Yes.
So say you, juror in seat number 14.
Yes.
And so say you, juror in seat number 16.
Yes.
Your Honor, may the verdict be recorded.
It may.
Thank you.
Please be seated, jurors. Please be seated, everyone else. Jurors, I make no comment upon your verdict. As I've told you over and over again through the course of this trial, that's exclusively your prerogative. I would like to thank each and every one of you and our 4 alternates for their service in this case. I'd like the opportunity to thank each of you in person. If you're able to stay around for just a few minutes, I'll come down to the jury room imminently. But if anyone needs to leave right away or simply wants to leave right away, I certainly understand that. My thanks to you right now will have to suffice. You have fully discharged your responsibilities as jurors in this case, each and every one of you, so I am now excusing you and discharging you once again with our thanks and gratitude.
All right. Judge on the floor.
Court is back in session. You may be seated.
Let's set a sentencing date. I suggest later this week. Wednesday would work well for me. Our counsel available?
Is it possible to do Thursday or Friday? I have to be here both of those days anyway.
I could do Thursday in the morning. I can't do the afternoon. Mr. Narkunis and Mr. Scully?
Judge, may we have a moment to confer? We both have matters we've been trying, you have to catch up on as well.
Certainly.
I'm available Thursday.
Thursday, Judge.
All right. Let's say Thursday at 10 o'clock.
Thank you, Your Honor.
All right. Thank you all. We'll be in recess.
Court, all rise.
All right. All the parties are present. I understand Mr. Torberson can't, he's stuck in some other hearing or something.
Yeah, he is not available at the moment, Your Honor. He said we can go ahead and proceed.
Okay.
He apologizes, but.
No, yeah, I mean, it's okay, at least one of you's here. So all the parties are here, everybody's present, except for Mr. Torberson because of conflict. One thing I do want to say before we bring the jury in, this case is obviously very emotional, very difficult for everybody, and I just want you all to realize that this is the process. I still expect there to be decorum. I expect there not to, I'd ask you not to shout out, not to say one thing or another. Please leave orderly at the end, whatever the result may be. And I'll say, and just one last thing is that a case like this, and I've had a number of them, it is raw emotion which is there, and I know that. It is very important that we deal with this in this way. And so I ask for all of you to take that into consideration, and ultimately we all are grieving over this situation. So having said that, let's bring the jury in.
If you haven't turned off your cell phone or put it on mute, I don't want to see any cell phones.
Thank you. Sorry about that. I should have said that. All right, everybody may be seated. And has the jury reached a verdict?
We have, Your Honor.
Okay, could you hand the verdict, hand it to Terry and she'll hand it over to me? Thank you. Make sure we have all the 6 pages. That's great. Okay.
State of Wisconsin versus Josie Dikeman, La Crosse County case number 23 CF 475. Count 1. We, the jury, find Josie Dikeman guilty of first-degree reckless homicide as charged in count 1 of the information. Verdict for count, signed by the foreman. Verdict for count 2. We, the jury, find Josie Dikeman guilty of chronic neglect of a child. Consequences is death as charged in count 2 of the information. Signed by the foreman. Count 3. We, the jury, find Josie Dikeman guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. Did at least one violation cause the death of the child? No. Did at least one violation result in great bodily harm to Alexavier Pedrin? Yes. Signed by the foreman.
So as to those verdicts, I'm going to ask you as a joint, you just say yes at first, but then I'm going to go through each verdict. The first question is that your verdict as a jury?
Yes.
Right. So what I'm going to do is I'm going to go through each one. I'm going to poll the jury. Then I'm going to go through each one of you. I'm going to use numbers 1 through 7, 1 through 5 here, 1 through 7. to 12, excuse. So, first of all, juror number 1, is that your verdict as to count 1? Actually, the person behind you. All right. Juror number 2, is that your verdict as to count 1? Juror number 3, is that your verdict as to count 1? Juror number 4, is that your verdict as to count 1? Juror number 5, is that your verdict as to count 1? Juror number 6, is that your verdict as to count 1? Juror number 7, is that your verdict as to count 1? Juror number 8, is that your verdict as to count 1? Juror number 9, is that your verdict as to count 1? Juror number 10, is that your verdict as to count 1? Juror number 11, is that your verdict as to count 1? Juror number 12, is that your verdict as to count 1? Juror number 1, is that your verdict as to count 2? Juror number 2, is that your verdict as to count 2? Juror number 3, is that your verdict as to count 2? Juror number 4, is that your verdict as to count 2? Juror number 5, is that your verdict as to count 2? Juror number 6, is that your verdict as to count 2? Juror number 7, is that your verdict as to count 2? Juror number 8, is that your verdict as to count 2? Juror number 9, is that your verdict as to count 2? Juror number 10, is that your verdict as to count 2? Juror number 11, is that your verdict as to count 2? Juror number 12, is that your verdict as to count 2? And juror number 1, is that your verdict as to count 3? Juror number 2, is that your verdict as to count 3? Juror number 3, is that your verdict as to count 3? Juror number 4, is that your verdict as to count 3? Juror number 5, is that your verdict as to count 3? Juror number 6, is that your verdict as to count 3? Juror number 7, is that your verdict as to count 3? Juror number 8, is that your verdict as to count 3? Juror number 9, is that your verdict as to count 3? Juror number 10, is that your verdict as to count 3? Juror number 11, is that your verdict as to count 3? Juror number 12, is that your verdict as to count 3? As indicated, with that, members of the jury, you have completed your duty as your jury duty. Not only that, your duty for this trial. It's been a long 3 weeks. I want to thank you for your time. I do want to come back and talk to you a little bit. It's about some information we're handing out for these type of trials, basically about trauma and some other issues. So if you can stick around a couple minutes, we should be there. We'll need to talk a little bit here as to what to do next, and I'll be right out. So thank you so much. We'll see you in a bit. Everybody may be seated. Obviously, first of all, the question for the state, any objection to how the court did the polling?
No, Your Honor.
Defense, any objection to how the court did the polling? Obviously, there's conviction for each one of these counts. It's not it's the lesser included. It's essentially on count 1 and 3. It's the version on 2. Because the convictions have been, well, Mr. Toverson, if you want to come on up, that's fine. The court will go ahead and, at this point, accept those verdicts. I'll enter them into the record. The court's going to order a pre-sentence investigation and order a sentencing. It's probably going to be more like 60 days, just simply for the complexity of this. Given the seriousness of these charges, given everything else, I am going to revoke the bond at this point.
I'd like to be heard on that, Your Honor.
Go ahead.
Judge, since the state's primary witnesses, one of them is an admitted perjurer, the other two were obviously lying, given Ms. Dikeman's bond compliance throughout the course of this case, given the fact that the man actually responsible for this child's death is seated free in the back of this courtroom, we're asking that the court continue her bond while we prepare her sentencing.
State's position?
the jury's found her responsible for the death of this child. The presumption of innocence is gone. She should be remanded.
The court's remanding her into custody at this point in time on the basis, not only, I know she's been very compliant with bond, but these are very serious charges. She is found guilty at this point. I agree with the state. I think the other issue we raise is not for this court to decide. That's for a different forum. With that, the court will remain her into custody right now. As far as the case goes, we are concluded as of today. I'll get a date for the sentencing. There might be an alternative PSI, maybe.
Judge, a couple things. One, Ms. Dikeman maintains her Fifth and Sixth Amendment rights to silence and does not wish to be questioned by any law enforcement officer or agent of the state while remanded. Two, I'm asking the court to order that the PSI not come with a specific recommendation due to the anchoring effect and due to the fact that the recommendations vary widely and are inconsistent with State versus Galleon. Number three, I can tell the court that we're going to advise Ms. Dikeman not to cooperate with the PSI and meet with the agent. And number four, I am told that there should be some exculpatory reports that we have not received regarding at least 3 different witness interviews and the laboratory testing of the substance which proved to be sucrose, allegedly. So I'm putting that on the record that we are still requesting those reports.
Okay. So obviously I'm still going to order a PSI for the background information, even if she doesn't participate. As far as the issue of get a date, if you end up doing an alternative PSI, just let us know. Obviously, we need to give enough notice for everybody to be here for the sentencing, and plus for the victims to make their statements. Anything else today from the state's perspective?
No, thank you.
No, Judge Zacher. All right. So what I would ask is, why don't we have one of the families please leave, the other family stay here. Those in support of Ms. Dikeman, just stay here for a bit. Those who are other, please, if you want to go ahead, you can go ahead and file out. We just like you to sort of go at separate times. Correct, Brandon? We do that out of security just to make sure everybody's safe. All right, we're adjourned. Okay, I'll be back in.